Hello and welcome to Jurisedge Academy's YouTube channel. In this video, we are going to discuss important weekly legal news from 14th November to 20th November 2022. In first important news, the Supreme Court has held that contractual expressions must be understood as intended by the parties to contract. In the case of Food Corporation of India versus Abhijit Paul, the Supreme Court has observed that the scope of contractual expressions must be understood as intended by the parties to the contract. The court has held that words and expressions used in the contract are principal tools to ascertain such intention. While interpreting the words, courts look at the expressions falling for interpretation in the context of other provisions of the contract and also in the context of contract as a whole. The court has said that the process of interpretation, though the exclusive domain of the court, inheres the duty to decipher the meaning attributed to contractual terms by the parties to the contract. In second important news, the Supreme Court has explained the scope of judicial review of state action in matters of non-statutory contract. In the case of MP Power Management Company Limited versus Sky Power Southeast Solar India Private Limited, the court has clarified the scope of judicial review in contractual matters. The court has said that even if it is a non-statutory contract, there is no absolute bar in dealing with a cause of action based on acts or omission by the state or its instrumentalities, even during the course of the working of a contract. The court has said that the mere fact that the relief is sought under a contract which is non-statutory, it will not entitle the state in a case by itself to ward off scrutiny of its action or inaction under the contract. In third important news, the Supreme Court has directed one of the juvenile accused in Kathua Rape case to be tried as an adult. In the case of State of Jammu and Kashmir versus Shubham Sangra, the court has held that the respondent accused was not a juvenile at the time of the commission of the offence and should be tried the way other co-accused were tried in accordance with law. So the Supreme Court has set aside the orders of the CJM and the Jammu and Kashmir High Court, which held that one of the accused was a juvenile. Lastly, the Supreme Court has said that benefit of set-off can be invoked only if detention undergone by the convict is in the same case. In the case of Vinay Prakash Singh versus Sameer Gehlot, the court has said that an indispensable requirement to invoke Section 428 of CRPC is that there must be a conviction. If these requirements exist, then the occasion opens up for applying the beneficial provisions of Section 428 of CRPC. However, for it to be invoked, the existence of detention undergone by the convict during investigation, inquiry or trial in the same case is indispensable. This brings us to the end of our weekly legal update. If you like this video, please like and share and subscribe to our YouTube channel.